हामिद खान साहब आप कंक्लूड कर लिया था ना?
मैंने कंक्लूड कर लिए थे। मेरी सिर्फ एक गुजारिश है कि ये केस इंडिपेंडेंटली अगर डिसाइड हो जाए, वो अपील है वो उसके अपने मेरिट्स पे होती रहेगी, इसको जरा कंसीडर कर लीजिएगा। तो दिस केस इज कंक्लूडेड।
आप क्या कहते हो, डू यू सपोर्ट दिस कंटेंशन और नॉट?
Lordship, of course, I do. The concern of the Bar Association was to the extent of initiating and then completion.
No, we've understood that. What is your point of view?
This is between the appellant and the prosecution. मुझे कोई इतराज नहीं है इधर। I think कि बार काउंसिल्स का ये जो कनेक्टेड मैटर्स थे वो सुने भी गए हैं, हियरिंग भी कंक्लूड हो गई, उसका इस अपील से कोई ताल्लुक।
It has no bearing on this.
It has no bearing whatsoever, sir.
Okay. चलिए ठीक है, we don't want to say anything definite, but we will certainly consider your joint request. आप कुछ फर्क कहना चाहते हैं?
नहीं सर,
नहीं आपसे
अभी हमारे नहीं पता क्या अभी पहुंची है सर, थोड़ी लेट हो गया।
नहीं, हमने वो कॉन्स्टिट्यूशनल एस्पेक्ट तो कंसिडर कर लिया है।
हमारे खान साहब के हो गए
तो सलमान साहब ने
तो इनको ऑन किया।
नहीं ठहरिए ना, 2 एस्पेक्ट्स है ना केस के। एक था Lahore High Court had invoked the constitutional jurisdiction,
sir,
which even Mr. Salman said was not proper.
बिल्कुल सही।
Khan Saab, we've heard everybody on the constitutional aspect, whether the Lahore High Court had correctly assumed jurisdiction when the law provides for an appeal.
Sir.
So, आप लोगों का कहना था कि that was wrong. अब खान साहब की रिक्वेस्ट आई है, हामिद खान साहब की, कि दोनों को अलग कर लें। कॉन्स्टिट्यूशनल जो एस्पेक्ट्स हैं, जो ये जो CP 3797 9899 3800 और कौन सी है, तो इनको अलग कर लें और इनकी जो क्रिमिनल अपील है वो हम सुन लें अलग। ठीक है, हमने सलमान साहब से पूछा, सलमान साहब ने भी कहा कि मुझे कोई इतराज नहीं है और इनफैक्ट ही सपोर्ट्स द कंटेंशन। इफ यू ऑल वांट टू बी हर्ड इन द क्रिमिनल अपील तो हम आपको भी सुन लेंगे, मगर आप नहीं सुनना चाहते हैं, आपको नहीं सुनेंगे। इनको हम क्रिमिनल अपील सुन लेते हैं इनकी।
जी बिल्कुल।
स्टेट, आई डोंट नो स्टेट की तरफ से कौन है क्रिमिनल अपील में? आप हैं क्रिमिनल अपील में? ठीक है
जी सर, जहाँ तक तो इस चीज
अगर कोई बात हुई हम देख लेंगे।
बिल्कुल ठीक है सर।
तो डू यू ऑल हैव एनी ऑब्जेक्शन टू द मैटर बीइंग सेपरेटेड?
नहीं, हमें कोई ऑब्जेक्शन नहीं है, बेशक सेपरेट कर दें सर।
ठीक है,
और बाकी अगर क्रिमिनल अपील पे हम अगर
ओके हम आपस में हमने नोट कर लिया आपका कंटेंशन, वी विल कंसीडर इट, लेट हिम स्टार्ट नाउ
सर। तो इस पे सर अगर क्रिमिनल अपील में अगर जनाब इजाजत देंगे तो हम अगर करना चाहें तो फिर
विल कॉल अपॉन यू। अगर कोई ऐसा खास लीगल इशू आ जाएगा तो आप कर दीजिएगा, अदरवाइज द स्टेट विल।
जी ठीक है।
आप अपोज कर रहे हैं क्रिमिनल अपील चौधरी साहब? Are you opposing the criminal appeal?
My lord.
ठीक है, तो अगर कोई कमी बेशी रह गई तो ये तो आप इनको बता दीजिए, या फिर हम
जी ठीक है
कोई लीगल पॉइंट हुआ तो
जी ठीक
हम सुन लेंगे। ठीक है, आइए सलमान साहब।
Sir, Lordship, I would like to begin by referring to the orders of the Honorable Bench on the last state of hearing. There were 3 parts to the order. The first part related to establishing contact with the relatives and with the legal heirs of...
You are representing someone or not?
I'm not representing anyone, sir. And this is despite repeated messages, hectic efforts. I went an extra mile to establish a contact. I even cooperated with the family, with the court staff. Notices were served at the residence Chak Shahzad. I had one telephone number of the way that was.
We believe you don't have to explain, give an explanation. I'm just saying, do you represent anybody?
Your Lordship, I do not represent anyone from the family, and I do not have the instructions from the family either to proceed or not to proceed. So there are absolutely, it appears that of course that this appeal is being heard. The family is in the know, they are in the knowledge, they are not interested in pursuing the appeal. This is now visibly...
You got in touch with the family and they know that there's an appeal?
Your Lordship, I got in touch in a sense that messages were sent and were not responded, not even once. And this is since last year, November 23, more than 10 contacts which I established. Usually normal advocates don't go to that extent. But as an abundant precaution, or is wajah se, the family must have been, they were very anxious till the time he was alive, till the time the appeal was in the Supreme Court. But my last contact was at the death for the condolence, and after that there was no contact and there was no reply.
So there is nothing, nobody has told you directly that we don't want to pursue.
जी, so मेरी तरफ जी.
So वो तो नहीं.
This is
But
one
we issued
situation.
notices also to them.
जी. अब separately this honorable court has also sent notices और अखबार इश्तिहार भी हुआ, डॉन अखबार में भी गया, वो दुबई के एड्रेस पर भी गया, वो चक शहजाद पर भी गया और वो टेलीफोन के थ्रू भी मैसेज गया. So this was.
फिर ये अगर my learned brothers pointed out, then what do you make of 431?
Your Lordship, I will make
Can we read 431?
Your Lordship, then I would make my submissions.
Who are you making submissions on behalf of?
No one, sir. This is
on the
this appeal, Your Lordship.
at the time.
I can be here assisting my lords only in two scenarios. Scenario number one, if there is a punishment resulting in fine, there has to be punishment, not any other consequences, not pension, not attachment, not any monetary.
You're just assisting the court on the legal provision. What happens to such a case where a person is not represented?
Your Lordship, all the reported cases of the Honorable Supreme Court, as many as 4 that I have today, all the cases proceeded, and the way forward was after the legal heirs had stepped in, they were replaced, and an application was filed according to Order 15, Rules 6 and 7 of the Honorable Supreme Court. And if the court, after hearing these submissions, only in case of fine. Now in this case, for high treason, for Article 6, the only punishment prescribed is death sentence or imprisonment for life.
Mr. Salman, it's not actually an appeal before this court. As the appellant, it was numbered just to make it visible that it is appeal pending before this court. The appellant has never surrendered before this court.
You never surrendered?
Therefore, it was not actually
Your Lordship,
numbered.
I thought, Your Lordship, चूंकि इसमें कुछ ऐसे मामला थे, and this is indeed
No,
very
but since
unfortunate.
you had given some reasons that his non-surrendering was on account of ill health.
Yes, sir.
So we were more accommodating.
Of course, sir.
But then we expected that the legal heirs, or one or more of them, would come forward. So then there is nothing before us to
Lordship,
decide.
I had
We are not deciding
I
anything.
had drafted some very engaging points for my lords.
We appreciate.
And I'm even today very anxious कि एक दफा मुझे वो if I'm able to overcome the hurdle and the impediment, which legally I cannot assist my lords any further after his death and after the family not coming forward and in the absence of
So
fine.
in regular cases, when we look at 431,
Sir.
if the appellant passes away,
Sir.
the appeal abates.
Abate, sir.
So that's the legal position.
That's the legal position.
So
You are
Since
not.
there is no fine.
There is no exception.
And no one is here to engage me. I cannot represent a dead person.
And in this particular case, we've reached out to the legal heirs, but on repeated
Repeated,
notices,
Your
they're not coming.
Repeatedly.
And it's been widely reported in the media, so I doubt it that they won't know
course.
about it.
Your Lordship, this honorable court has gone out of the way, but of course, एक गिला of course उनका बन सकता
I
है.
was really looking forward to hearing your
Lordship, मैं-
submissions,
I
Magar.
was equally anxious, but perhaps maybe some other day, some other case. Your Lordship, for 3.5 years, बदकिस्मती इस केस की क्या रही है, मैं वो जरूर हाईलाइट करना चाहूंगा. एक ये कि 6 साल की ताखीर के बाद केस स्टार्ट होता है. Should have high treason should have been noticed, should not have gone unnoticed. Instantly, the federal government should have been in action. वो नहीं होता.
You want us to plead guilty?
6 साल के
What
बाद
can we
सर.
do? देखिए Salman Sahab, for what we are trying to do. I know you're not the only person who's complained this.
जी.
Of course, everybody can weigh his turn. if it's predetermined, first in, first out. I mean, naturally we can't hear 55,000 cases simultaneously.
sir.
But if there's a system, first in, first out, first in, then
burden is not
even in the
lessening.
Sindh High Court, I
It's
would
only increasing, like वो pyramid approach तो है ही नहीं ना, वो same amount of cases
नहीं,
are
तो
landing
वो
in the
अब
Supreme
देखें, अब we are trying to restructure things,
Sir.
minimizing discretion or in fact finishing discretion, and unless there are good reasons, I mean, there are cases which become irrelevant, after a certain period of time. It could be election dispute, it could be a custody order. There are various naturally inbuilt, you have to have them decided, or the law stipulates that it should be done. And I think in this case, you are absolutely correct that the law, if it does not stipulate, it certainly heavily implies that these sort of, it's not an everyday case, it should be attended to as quickly as possible.
Your Lordship. For 4 years, it was high on the shelves in the registrar office.
So we are trying, we did this to do this. They had the same complaint. CP is not being heard, so at least we've got them fixed.
But Your Lordship, may I submit, even if the family was here today and would have instructed me to proceed with the appeal, the Indian jurisdiction in the relevant section is 436,
In
perhaps.
that case, 431 has to be independently challenged
It has to be.
because either it's not constitutionally correct or requires
It has to be challenged.
It has to be challenged.
Abhi tak
Now,
ki settled jurisprudence, uniform and
you'll
consistent.
have to
approach.
challenge 431 to say it's unconstitutional and it access to justice
Your
affect
Lordship.
करता है, तब फिर हम आगे
तब
चलते हैं।
फिर आगे बढ़
अभी
सकते
तो
हैं।
instructions ही नहीं कुछ करने की, तो वो कैसे?
And Your Lordship, the 4 reported judgments that I have today, all of them are through legal representatives. All of them, not a single. So
Can you give us a list of those cases?
those cases.
No, but in those cases, this is a Pakistani jurisdiction.
Pakistan?
No, so if the person had passed away, they allowed the legal heirs to argue the matter.
Only if there is a fine. Even for
Is that
compensation.
provision available in 431?
Yes, sir. The only exception is fine. Your Lordship, the first judgment is
जी बताएं.
2020 SCMR 359.
2020 SCMR
359. This is through legal heirs, judgment authored by His Lordship Mr. Justice late Qazi Muhammad Amin Saab.
जी.
And Your Lordship, इसमें उन्होंने लैंडमार्क जजमेंट जिस पे रिलाई किया जाता है जस्टिस कॉर्लिनियस की है 1971 SCMR 35. This was a judgment through 8 legal years. 1971 की जो judgment
71 SCMR?
1971 SCMR 31, sir.
और पहले क्या लिखा है यार?
जो पहली जजमेंट है 2020 SCMR 359.
351.
359, sir. The second judgment, जिसमें my Lord Mr. Justice Mansoor Ali Shah Sahab was also a part and parcel. 2019 SCMR 1144. Lordship Mr. Justice Manzoor Ahmad Malik Sahab, Qazi Muhammad Amin, and Mr. Justice Mansoor Ali, authored by Qazi Muhammad Amin Sahab.
What did it hold?
Your Lordship, this again said that only if there is a monetary punishment arising
So
from
that passes on to the legal heirs.
G, Your Lordship. The third one is, Your Lordship, this is a 5-member bench judgment, 1971-35. This is authored by Justice S.A. Rahman, and there is a disagreeing opinion by Justice Cornelius. That is also very important.
ये क्या citation?
This is 1971 SCMR 35.
आपने लिखा है 71 SCMR 31?
35, sir.
अच्छा 35.
वो तो आपने कहा कॉर्नेलियस साहब का जजमेंट है.
Cornelius साहब का एक additional note है उसके अंदर on abatement.
So you've given us 3 judgments.
I've given 3. There is a 4th one, sir.
जी.
The 4th judgment is PLD 1967, Supreme Court 42. These are the 4 judgments of the Supreme Court which are repeatedly referred to.
42.
And then, Your Lordship, there is one judgment.
What is the principle?
The principle is, Your Lordship, that with death, corporal punishments are exacted from the body and from the person. And if the person is in the grave, that is the end of the matter. Appeal is abated in terms. Black's Law Dictionary की मैं definition को भी जरूर refer करूँगा. It nullifies, it eliminates, the claim ends.
Oh, how would you attend to, if I put it to you, if my father is now a convict murderer and he filed an appeal, and the son, the family, subsequent generations will suffer from a stigma,
Your Lordship.
though it's not a financial thing.
Think about it.
Though it is not a financial thing, why should they be deprived
Lordship.
of exoneration?
Lordship, unfortunately, the way criminal jurisprudence should have developed, it has not. And what is happening in the US, agar aaj in 2023 with the aid and help of DNA technology,
नहीं वो एक अलग बात है.
आज भी वो कहते हैं आप स्पॉन्सर
नहीं, एक
करें और स्टिग्मा को वॉश
एक
करें.
नॉर्मल अपील में
और अपील किस सेक्शन
कभी तो होते हैं ना फाइनेंशियल चीजें कि जी मुझे वो रिटायरिंग बेनिफिट्स वगैरह whatever. But within the constitution, the fundamental rights, anything in
I
favor
have
of you.
attempted for the past 23 years, this is what I do day in, day out, murder appeals. More than 3,000 I have argued in High Court, and on many occasions I have tried arguing an appeal of a dead man, but never had luck, ever. So I was very anxious case.
Maybe you never came before me.
Too late in the day, sir.
You may have been luckier.
Your
No, but
Lordship,
here the question, there's another added problem. I just thinking aloud. I think at the end of the day, everything revolves around fairness. And I don't see a good reason for a person who wants to vindicate the name of his deceased, whatever, father. Why should he be prevented? Because, I mean, it also affects that person. I mean, you are the son of that murderer. I mean, you know, okay, it has societal consequences, it has family consequences. So but here we have the added problem that none of the legal heirs are coming forward. So let's not kill it completely. Let us keep it alive, the issue.
1898 में रुक गई बात, आगे
Maybe
नहीं
let's
बढ़ी
keep
जी.
the issue alive
जी.
because after all it's a code of criminal procedure.
No, what about
So it is not technically speaking, I mean, you know, it has legal things, but we can look at certain constitutional provisions, the fundamental rights. I don't know if you can have an expanded discussion on Article 10A, right to fair trial, and appeal is incorporated in it, and appeal is a right, and sort of, you know, removal of a stigma is a right, and all that.
वो तो एक दफा पंडोरा's box खुलता है तो फिर वो सारी
नहीं, मगर वो इस केस में हम कर नहीं सकते क्योंकि कोई
For whom 10A
मगर अगर आप उनके लीगल हेयर होते तो आप सुन लेते मगर आप तो वकील हैं इस केस में.
legal heirs क्योंकि नहीं है. In another service matter we've also said survivability रहती है स्टिग्मा की वजह से वगैरह वगैरह, लेकिन legal heirs must come and say that.
उनके बगैर आगे
एक तो वो सवाल प्रॉब्लम, दूसरा
इसलिए मैंने 3 दफा I sought adjournments, inconvenience caused weeks की वजह से.
One is the fine in the sentence itself, but there could be other monetary consequences like pension and all. That's not covered.
वो मैंने judgments, वो चूंकि सुप्रीम कोर्ट की नहीं है, ऐसी कई केसेस आए जहां पर उन्होंने कहा सर्विस बेनिफिट्स इफेक्ट हो रही है, पेंशन इफेक्ट हो रही है.
That's not covered.
The honorable judges, वो हाई कोर्ट की जजमेंट्स है, मैं वो भी लिस्ट सबमिट करवा देता हूँ. 5 से 7 ऐसे केसेस हैं. They were not entertained. उन्होंने कहा number 1, it has to be punishment, that to fine. Even there is one landmark judgment, sir. आज तक एक जजमेंट आई है authored by his lordship Mr. Justice Amjad Rafiq of Lahore High Court. It is a very elaborate judgment, a treat to read as well. He has developed the उन्होंने jurisprudence सारी डिस्कस की है, law of abatement, जिसमें ये सारे फैसले भी रेफर किए हैं. And what he had observed उस केस में compensation थी, fine as well as compensation for 302, or compensation was also substantial 5 lakh rupees. Legal heirs came, were aggrieved, और उसमें लिखा हुआ है legal heirs were very anxious. स्टिग्मा वाली बात भी थी. उन्होंने कहा कि compensation भी 544 की नहीं आती because that is not punishment, that is a consequence. So consequence would not be entertained. It has to be, so punishment, तो वो तो आर्टिकल 6 और
नहीं, अगर हम इसकी सॉरी कॉन्स्टिट्यूशनैलिटी एग्जामिन कर रहे होते ऑन द बेसिस ऑफ द लीगल एयर्स हियर, then this could have been a ground on the survivability of the issue, but वो है ही नहीं, सारा सवाल ही नहीं चल सकता.
What would you say about section 561A of the Criminal Procedure
जी
Code?
लॉर्डशिप वो
If you can first read it.
जी inherent powers तो हैं.
So,
But there's a specific provision.
all the provisions of the CRPC are subject to 561.
वो तो होती हैं सर.
Salman Saab,
Sir, please.
sorry, for my
जी
understanding,
सर प्लीज सर.
this appeal has been filed under subsection 3 of section 12 of the Criminal Law Amendment Special Court Act 1976.
Sir.
How does the Criminal Procedure Code is attracted in case of this appeal?
मैं अर्ज करता हूँ.
Because the special law does
मैं
not
अर्ज
say
करता
so.
हूँ. Your Lordship, I was anticipating that question and I have come prepared on that point. मैं असिस्ट करता हूँ सर. So kindly see. पहली बात तो ये है. Section 431 refers to all appeals. Section 431 on 2 occasions refers to law to death. Death has been explained in the law of abatement. इस सेक्शन में 417 का भी जिक्र है, which is appeal against acquittal, कि वो भी अबेट हो जाएगी. जो जिस सेक्शन की तरफ जनाब इंडिकेट कर रहे हैं, रेफर कर रहे हैं, 12(3), वो है any party who is aggrieved from the final order or judgment of the special court. So it could be an appeal against conviction, it could be appeal against acquittal.
I think the question is whether Criminal Procedure Code applies to that tribunal.
Your Lordship. Number 1, sir, definitions में section 2A,
When it comes to
CRPC applies.
Special law.
Special law. Sir,
Section-
first of all, I would refer to 2A.
Section 13 पढ़ लीजिए.
मैं 13 पढ़ लेता हूँ. ये जी ओवरराइडिंग इफेक्ट है सर. लॉर्डशिप, आपकी इजाजत से इससे पहले 12(3) में जिसमें अपील है, एनी पार्टी एग्रीव्ड बाय द फाइनल जजमेंट of the special court may prefer an appeal to the Supreme Court within 30 days of the passing of the
So
judgment.
now this appeal has not been filed under any provision of the Criminal Procedure
It has been, sir. मैं अब यही justify
It
करता
has
हूँ
been filed
कि
under this
वो
special
कैसे.
law.
Your Lordship, this is
पहले 13 जरा पढ़ लीजिए.
जी 13, sir. The provision of this act shall have effect notwithstanding anything contained in the Code, the Evidence Act 1872, or any other law for the time being in force overriding effect. Now, Your Lordship, my submissions to satisfy my Lord on that query would be, number 1, this is not an appeal under section 185. This is a direct appeal to the Supreme Court for the first time. This is a case of first impression. Never before anyone has been tried for high treason. And this law has been very rarely put into use. Very rarely. There are no reported judgments of this special law. Section 2A of the law, the opening lines, code to govern the proceedings is CRPC, 2A. Then the entire case, 87 हुआ, 88 हुआ, 265K हुआ, 512 हुआ, 514 हुआ, 342 हुआ, वो सब का सब यहाँ रेगुलेट हुआ.
दूसरा ये भी है कि जो 13 to my reading of 13 is that if there's any provision in this act which is inconsistent with the
Inconsistent.
code, then code will not apply.
So,
But
मैंने
not,
उसको उस एस्पेक्ट को भी Your Lordship देख
Are
लिया.
you, this is the one and only trial ever taken place pursuant to this law?
In Pakistan, sir.
Naturally, all
Yes.
there is.
कहीं और तो नहीं लगता ये law.
Yes, sir. This is a case of first impression or
Now can you come to the 561A, unless you have to say more on this?
Your Lordship, मैं इसको conclude कर देता हूँ कि इसमें अगर कोई मेरे पास और फाइल, एक तो I would like to refer to the definition of abatement in blacks.
आपने जो बात अर्ज की, आपने कहा कोड अगर इससे तसादुम रखता है तो ये लॉ प्रिवेल करेगा, अदरवाइज कोड के प्रोविजंस
मगर
एप्लीकेबल
जितनी भी
हैं.
रिपोर्टेड जजमेंट्स हैं टेररिज्म पे, नैब की, एंटी करप्शन की, स्पेशल कोर्ट्स की, जितनी हैं, the principle is with death the corporal punishment, monetary nahi hai sir, are exacted from the body. The body is no more, the appeal will abate, it will not continue. Continuance is a possibility if family steps in through Supreme Court rules, through a formal application, that too. आज सर फैमिली आ भी जाती, the law of the country does not permit the family, this is my speaking for myself, unless my lords would permit them, stigma ground पर फाइन नहीं है.
अच्छा,
जब फाइन नहीं है तो फैमिली आ भी जाए,
नहीं वो हम देखिए, हम दरवाजा बंद नहीं करना चाहते हैं,
एग्जामिन ही नहीं कर.
हम उधर आज हमें ऐसा देखिए, एक बुनियादी असूल ये होता है कि मफरूजों के बेसिस पे आप फैसले ना करें.
जी सर.
तो कल किसी की राइट चली जाए और वो कहेंगे जी आपने तो अपने आप पे ये, तो एक्चुअल कोई आएगा लीगल एयर्स वो शायद ये पॉइंट रेज करे, तो हम इसको दरवाजा बंद नहीं करना चाहते हैं. ये तो आपको वाज़ेह तौर पे कर दें. मगर मैं सिर्फ वजाहत के लिए आपसे पूछ रहा हूँ, 561A में अगर हम दरवाजा खोलना चाहते तो वो ही लीगल अर्ज का खोलते, मगर हम 561A का सहारा लेकर के शायद खोल सकते या नहीं खोल सकते.
आर्टिकल
ऐसी आपकी सिंस आप मौजूद हैं और माशाल्लाह काफी महारत है क्रिमिनल लॉ में, इसलिए हम आपका प्रेजेंस का फायदा उठा रहे हैं. प्योरली एकेडमिक.
I must confess this was the most difficult brief that I have handled so far. High treason इससे पहले कभी ऐसा था नहीं, आप यहाँ से अंदाजा लगा लें सर. It came to me as a surprise. There were as many as 21 prosecutors appointed to bring home the guilt of the appellant, and I was the only one defending him, and that too, जो मेरा एक गिला था.
गिला
जी योर लॉर्डशिप था.
ये तो फिर आपका तस्दीक कर रहे हैं कि I am equal to 21.
Your lordship, even I was ousted from the proceedings. और वो then I had to go to the Islamabad High Court.
चले वो छोड़ें, ये
came to my rescue और मुझे
वो सुनते बाद में, मगर ये पॉइंट बताइए.
Your lordship, 561 आपने
जी
कहा कि मैं वो
10A पे खड़े होते हैं.
नहीं 10A पे खड़े होते, 561 पे खड़े होते, ऐसी
लॉर्डशिप ये तो हम अगर वो शुरू करेंगे तो ऑफ कोर्स एक नई विंडो खोलनी पड़ेगी, और उसके लिए if my lords are inclined,
नहीं we will
That would only be if the legal aids had come
कोई आए तो
and they had challenged the violations.
अगर कोई आता तो हम खोले ना.
लॉर्डशिप अब वो कहना मुनासिब तो नहीं है, because I already appreciate the steps this honorable court has already taken. The legal heirs are not in the country.
नहीं वो हमें उनको पता चल गया है.
चल गया.
अच्छा, अब एक सवाल मैं अगर आपसे पूछूं, you said you had very grave reservations about the Lahore High Court. What were the grave reservations about the Lahore High Court?
Your lordship,
You said I do not even appear in.
Your lordship, I was assisting. My engagement was to the extent of.
ऐसी पूछ रहा हूँ. CP में आपने बहुत ही बिल्कुल.
उसके बाद वो तो लॉर्डशिप I am not before the honorable judge for many years, even in the Supreme Court of Pakistan.
Why?
So मैं पेश उनके पास
नहीं. You want to disclose or not?
I would not like to disclose. जनाब मुझे in chamber person तलब करना चाहेंगे, मैं explanation.
नहीं हम chamber में नहीं बुलाते किसी को.
Shah Saab is aware, but for personal reasons, purely for personal reasons.
Shah Saab is aware.
Yes.
लॉर्डशिप मेरी एक प्रिंसिपल पोजीशन भी थी, स्टैंड भी था, तो मैंने इन ऑल फेयरनेस मैंने उनको वो आर्ग्यू करना चाहते थे, वो किया, बट और इन द मीन वाइल मैं ये भी एक्सप्लोर कर रहा था कि फैमिली मुझे देयर हैज टू बी अ फ्रेश एंगेजमेंट. मैं ये भी कहना चाहूंगा माय प्रोफेशनल ऑब्लिगेशन
टर्मिनेट्स ऑन डेथ ऑफ द वकालतनामा खत्म हो जाता है, कॉन्ट्रैक्ट खत्म हो जाता है, वकालतनामा खत्म हो जाता है, क्योंकि कल आके वो कह सकते हैं आपको किसने इजाजत दी.
किसने इजाजत ये
ये लोगों को बुलाएं. ये
प्लीज सर
एक चीज बताइएगा related to this You see, this was a case which was forced upon the federal government by this court, but they did not go back to 12th of October. Now, in the light of the amendments made in the Constitution, Article 270, AA, read with Article 12, is the door still open to proceed against those who collaborated in what had happened on 12th
Lordship,
October?
Had I been given the mandate to argue the appeal, my opening grounds would have been that this is a case where a constitutional crime has been investigated and prosecuted in an unconstitutional manner. For the reason, the obvious, the visible, the aiders, the abettors, the collaborators, those who were involved in the consultation process were dishonestly, there was a let-off. All the members, ये National Assembly में ये सारी की सारी endorsement हुई इसके ऊपर, Prime Minister की involvement थी, Law Minister की involvement थी, Proclamation of Emergency के आप ऊपर देखें कि कौन-कौन से लोग हैं जो involved थे, even honorable judges as said by.
For myself, I have a different view. Were not been legalized, legitimized by this court, there would not have been 3rd of November.
Of course, sir.
But could 3rd of November have been directed, the federal government could have been directed to initiate from 3rd of November and leaving or ignoring 12th of October?
Your Lordship, this was actually attempted right before the decision of the special court. The old prosecution team was notified, denotified, and a new one was notified who stepped in and filed an application that this complaint has not been filed correctly. And there should be certain amendments and changes in the number of accused and an allegations as well. But that application was not entertained, and in a haphazard manner, without recording 342, without listening to my submissions, closing speech, without leading defense evidence, a judgment was handed down, which was not a unanimous judgment. Magar ये अटेम्प्ट होने की कोशिश इस ट्रायल के अंदर भी हुई कि आप इन सारे ओवरऑल whoever was involved, इसका कैनवस बहुत वाइड था. Why target and narrow it down only to one person? This is repellent to common sense that these actions could have been taken single-handedly by one person without the advice of everyone.
नहीं तो खैर ये तो मफरूजों में जा रहे हैं मगर ये तो उससे तो कोई बात नहीं होगी कि कलेक्टिविटी विल abolish the individual act.
वो है. It only points towards unfairness.
अच्छा हम जरा 5 मिनट के लिए उठते हैं और शायद फिर आज ही सुना दें उस सीपीज में भी. उधर तो आपको कुछ नहीं कहना है ना, और इसमें भी ठीक है.
Thank you.
I hope you're not holding us responsible for that. Achha. No, it's been a pleasure hearing you.
Thank you very much.
Because without making any disparaging remarks on any other criminal lawyers, but criminal lawyers generally do not go deep into the subject, consider the actual constitutional and legal aspects of the case. इसमें लिखिए ये क्रिमिनल अपील नंबर 785-2020. This appeal was filed by General Retired Pervez Musharraf. In this appeal, General Retired Pervez Musharraf was arraigned as the appellant, and the Federation of Pakistan and the Special Court and the state were arraigned as respondents. The appeal, the appellant had not surrendered himself to the court and had contended, and it was contended on his behalf that he was indisposed abroad and not in a position to appear. Full stop. The appellant was convicted with a judgment dated 17 December 2009. 19, sorry, I beg your pardon. And the appeal and the instant appeal was filed on 16 January 2020 under section 12 within bracket 3 of the Criminal Law Amendment within bracket Special Court bracket closed Act 1976. To consider the office objection and full stop. When did he pass away?
So this is 5/2/23.
Mr. Salman Safdar. Learned Mr. Salman Safdar, representing the appellant, pointed out that the appellant passed away on
5th February 23.
5th February 2023. And would be contacting his legal heirs to take instructions. The matter came up before this court on 10th of November 2023, and opportunity was granted to Mr. Salman Safdar. Full stop. This court also issued notices to the legal heirs of the deceased appellant on all the available addresses, both within the country and abroad. Notices were also published in the leading English newspaper Dawn and the leading Urdu newspaper Jung, and on 28 November 2023. The following two questions were also framed within bracket 1. Whether on the death of the appellant, the appeal did not abate in terms of section 431 of the Code of Criminal Procedure, 1898, semicolon, and within bracket 2, if the conviction of the appellant is upheld, the consequences thereof, including on the rights, benefits of the appellant and his legal heirs. Full stop. Mr. Salman Safdar, the next paragraph. The Honorable Mr. Salman Safdar states that did you manage to make contact or you failed to make contact?
Failed to make contact.
That
Did not respond to my messages. Is more
the Honorable Mr. Salman stated that he sent out a number of messages reaching out to the legal heirs of the appellant, but did not receive any response therefrom. Full stop. This court has also attempted to though not obliged to do so, but in the interest of justice, had sent messages, had issued notices to the legal heirs on all known addresses in Pakistan and abroad, and as stated above, had also had notices published in the newspapers. Full stop. However, there is no appearance on behalf of any of the legal heirs, and Mr. Salman Safdar candidly states that under the circumstances, and Mr. Salman Safdar states that since none have approached him, let alone engaged him, the instant appeal would abate in terms of section 431 of the code. Full stop. In view of the fact that there is, full stop, without in the given circumstances, and as none of the legal heirs have come forward, we have no option but to hold that the instant appeal has abated. Consequently, the conviction of the special court we will attend to the other matter subsists. Full stop. अब अलग order लिख दें. The CPLAs. वो अभी सारी प्रेजेंस वगैरह हम नोट करें.
3797 है फर्स्ट तो फिकास
वो डेट कौन सी थी फर्स्ट डेट? वो ये तो क्रिमिनल अपील हो गई ना. अब बाकियों के ऑर्डर्स कहाँ हैं? पहली वाली 3799 है.
97 है फर्स्ट.
हाँ 37
ये ना लॉयर क्या
99 पेज पे.
अब ये ऑर्डर अलग लिख लें और ये ऑर्डर अलग लिख लें. ठीक है, इसमें लिखिए in these petitions, ये सब की प्रेजेंस लिख लीजिएगा. इसमें लिखें for reasons to follow the impugned judgment of the High Court dated
13/20. शुरू में लिखे
No date of hearing है.
आपको आखिर में कोई नहीं है।
Of the High Court passed in the date of hearing है ना?
लेकिन नीचे
Is it also the date of announcement?
वो नहीं है।
13th January is the date?
January
13th of January 2020 passed in passed by the Lahore High Court, Lahore, in writ petition number 71713/2019 is not sustainable and accordingly set aside. The instant petitions, by converting the instant petitions into appeals and allowing the same. Thank you for your valuable assistance. Khan Saab, I think you deserve the greatest of credit, and the bar associations have also made valuable contributions. And thank you, Mr. Safdar.
Thank you,
sir, for your. I will look forward to. Was looking forward to maybe in another case.
Another case.
I hope you will not appear before me.
I'm very anxious and looking forward.
Thank you, Jim.
Thank you very much.